Hello, everyone, and welcome back to Beyond the Evidence, the podcast where we dive deep into true crime cases, uncovering the facts and exploring the unanswered questions that keep us coming back for more. I'm your host, Marv, and I want to thank you for joining me today. If you haven't already, please subscribe to my YouTube channel and hit the notification bell so you never miss an update. And if you'd like to support the channel, you can find links to my PayPal and Cash App in the description. Now, let's get into today's topic.
In the shadows, where the truth lies, Marv's on the case, with justice in her eyes. Unsolved mysteries, voices lost in time. She digs deeper, uncovering the crime. Beyond the evidence, she'll fight the fight. Beyond the evidence, where justice matters. Marv's the voice for the voiceless, breaking all the patterns, facts and theories, clues and controversy. Join the journey, uncovering the mystery. This is Beyond the Evidence, where justice prevails, with Marv leading the way. Truth never fails. Now get ready for this live stream. Super chat, highlight your message. Don't fall victim to the irrelevance. Hit that like, share, subscribe to Marv's Beyond the Evidence. True Crime Rewind Podcast. Digging into the dark and mysterious world of the missing and murder. You seek the answers, but you never know what you'll find last. When you rewind. This is the True Crime Rewind Podcast. This is the True Crime Rewind Podcast.
Good evening, everyone. How are you? Anthony will be here. He is restarting his computer, but I'm also going to bring on our guest. Hello, Sterling.
Hey, thanks for having me again.
You're welcome. Nice to see ya.
Yeah, I'm not exactly sure how much I'll have to add, but hopefully I can learn something.
All right. Well, we're all hoping to learn something, right?
I would like to think so, yeah.
All right. Davey, welcome. You're one of the top 10 in the chat tonight. Jill Mosier, Typo, Roxana, Andrea's in the house. Hello, Mustang. Who am I missing? That's it so far that's chatted. All right. So, like I said, tonight we're going over the lawyer information and the phone information. So you said, Sterling, that you didn't know what was going on with the phone.
Well, I was a little confused about a lot of things. The lawyer information is one of them to start with.
Okay.
And But yeah, and then when you said the phone, I was just confused what you meant, and then I think what you meant was the audio jack being accessed, that part of the phone.
Yes, that's what I'm talking.
Okay, gotcha.
I want to say hello to it's me, to Linda and TLS and Angela and Miss Laura. Thanks for all joining us. Okay, so I'm going to present my screen because I have all the documents up here. And while we're waiting for Anthony, we're going to kind of go through this. This one we read. So when it comes to the safekeeping hearing, this is what the defense is really hammering on, that Richard Allen's rights were violated because his attorney wasn't at that hearing. And the information that they provided is an affidavit of Kathy Allen, stating that she's Richard's wife, and on October 26th, he was interrogated, arrested, and jailed. The next day, October 27th, she paid Brett Gibson, a lawyer in Lafayette, $5,000 to represent Richard Allen. Exhibit 1A is an email I received from Mr. Gibson's office acknowledging that I had paid Mr. Gibson to represent my husband. The evening of October 27th, Mr. Gibson sent a letter by mail to the Carroll County Sheriff and Nick McClelland, the Carroll County prosecutor, telling them he was representing my husband and they should cease all questioning of him. Exhibit 1B is a copy of that letter sent to me by Mr. Gibson. About 10 p.m., Mr. Gibson called me to say he would not be able to get my husband out of jail because he was going to be charged with murder the next day. So anything in there, Sterling, that you see that's interesting or didn't know?
Not in that one per se, but there was another document that I did. So yeah, I'm sure we'll get there.
So yes, I kind of got these in order. That's why you see the screen the way it is. So this is the email showing that she paid $5,000, and that they receipted it. This is to certify that on or before January 20th, 2025, the foregoing defendant's Exhibit 1A was served on all counsel of record. So it does say representation, Richard Allen, pre-arrest, Carroll County. Gives her name and address, Gibson Law Office address. So nothing major on that one. Now we have Defendant's Exhibit 1B. So this is, Dear Administrator, please be advised that I've been retained to represent Richard M. Allen in certain matters. Now, I've told you guys this before, wording is everything. I've been retained to represent Richard M. Allen in certain matters relating to an investigation being conducted by your office. It is my understanding that my client is being detained by Carroll County Sheriff. He will not be giving any statements regarding this matter. If he is currently being questioned, the interview should be terminated. If you have any comments or questions, please do not hesitate to contact me. And we know that this went to the jail and to Nick McClelland. And this is just Andrew Baldwin stating that he got this. All right, Defendant's Exhibit 1C, Affidavit of Bradley Rousey. I'm a lawyer with a law practice in Logansport, Indiana, and have been a lawyer in good standing in Indiana since I was admitted to the Indiana bar on June 7th, 2002. So now we know how long he's been a lawyer. Since November of 2022, I've been the attorney for Richard Allen, who is the defendant under the cause number. In an attempt to learn whether Richard Allen's first attorney, Brett Gibson, had communicated with either prosecutor Nick McClelland or then Sheriff Tobe Levenby or any other law enforcement officer concerning the fact that Gibson was representing Richard Allen effective October 26, 2022. I reached out to Brett Gibson via email asking him a series of questions. The purpose of my inquiry was to determine whether McClelland, Levenby, or any other law enforcement officer was aware that beginning of October 26, 2022, attorney Brett Gibson was representing Richard Allen after his, and they missed the D on here, Richard Allen's arrest on October 26, 2022. Sorry, guys, I just noticed things like this from the Tabitha case and other cases and documents that I look at. Attorney Gibson responded to my email inquiring and indicated that indeed Richard Allen had retained Attorney Gibson following Richard Allen's October 26, 2022 arrest. A copy of said email, which is marked as Defendant's Exhibit 1D, is incorporated with the affidavit. Furthermore, in his email response, Gibson stated that Attorney Gibson, communicated with Nick McClelland both by email and by cell phone, and alerted McClelland that Gibson was in fact Richard Allen's attorney. Furthermore, in his email response, Attorney Gibson stated that Prosecutor McClelland helped arrange a meeting between Gibson and Allen at the Carroll County Sheriff's Office, and said meeting did in fact take place between Richard Allen and Attorney Gibson, and that furthermore, Attorney Gibson advised Allen to not discuss this case over the phone. I've attempted to gain Attorney Gibson's affidavit concerning the things Gibson states in the email Exhibit 1D, but have been unable to do at this time. Anything in there, Sterling?
The certain matters part, you know, and I'm no lawyer, but if you represent him on certain matters, yeah, I don't know. I just feel like people in the chat talk about a letter of appearance, and I'm not sure that that's what this is or if that was filed. So, yeah, I'm just not clear as to, I'm still not clear though.
This is not a letter of appearance. As far as we know, he never filed an appearance for Richard Allen. So, interesting. Okay, so we're going to move to 1D. Now this is from Brett Gibson. It says, "Hi Brad, attached is a letter I sent to the Carroll County Sheriff's Office and an email I sent to Nick McClelland on October 27th, 2022. Did you ever communicate in any way with the prosecutor or any law enforcement officials before Richard's arrest? No. Did you ever communicate in any way with the prosecutor or any law enforcement officials after Richard's arrest? Yes. On October 27, 2022, Kathy notified me that Richard had been arrested. We sent a letter to Carroll County Sheriff notifying them of my representation. The sheriff confirmed receipt over the phone. However, the jail advised that Richard was not an inmate. And that is because they had put him in there with a fake name to try to fool all of us. I contacted Prosecutor Nick McClelland by email. He called me on my cell phone afterwards. He advised me that Richard was in the Carroll County Jail and they had him listed under a different name or alias. He arranged for me to meet with Richard at the jail that evening. Someone from the sheriff's office took me to a meeting room in the jail It appeared that regular jail staff did not know Richard was there. Let me know if you have any questions. Nick had been retained to represent Richard Allen. His wife, Kathy Allen, advised me that Richard was detained by Carroll County Sheriff's Office yesterday. She said he has not been released. However, I called the jail and they told me he's not there. Do you know Richard's whereabouts? Is he in police custody? I want to confirm any interrogation is halted. Please find attached correspondent. So that's pretty much clear information.
Yeah, and someone in the chat said my audio is bad, so let me know, okay?
Yeah, I don't hear that your audio is bad.
Well, anyone in the chat. So even if he did have this counsel, I'm thinking that somehow it's not going to grant him a new trial. You know what I mean?
No.
I think a lot of people are getting their hopes up that this proves that his rights were violated. Therefore, poof, he's just going to get an automatic new trial. And I'm just, not quite that confident, I guess.
Well, and my thing is what happened, because the safekeeping hearing happened on November 3rd, and on November 9th, the court received a letter stating that he couldn't get an attorney because it cost too much, and he had to have one appointed to him. So what happened between the time of these emails, his visit, and that safekeeping hearing to where he didn't put his appearance in or even come to the hearing? That's my question.
But Richard Allen was at that hearing?
Yes, Richard Allen was at that hearing.
I wonder if he was asked, like, if he had an attorney, like, at the hearing.
Yes, Sterling is the guest. Typo says I have a lot of questions for him. Let's see here. Did lawyer Gibson file it appropriately, like all defense lawyers know how to do? Well, that's the question, because there was nothing in the file stating that he put in his appearance with the court. Why is that? When was the sent date? This is different from date received. Let me go back. I closed them after I read them so I didn't get myself confused. Okay. So, from Brett Gibson to Brad Rossi, doesn't matter. You're asking when he actually sent the email to Tobe and McClellan, correct? Okay, so from Brett Gibson to Nicholas McClelland, date Thursday, October 27th at 6:36 p.m. Nobody knew about this other lawyer until now.
Is he a defense lawyer?
Yes, he is a defense lawyer.
Yeah, like I said, I think there'll be some discretion as to whether that point was a critical point of the case and whether he was hired or not. I just ultimately think it won't matter, but I know some people are hanging their hat on this.
I think Shelley's got a great point here. She said, I guarantee after Gibson met with Ari and told Kathy he was being charged with 2 counts of murder the next day and laid out what costs it would be for his services. So, when did this happen? When did this conversation with Kathy happen? Not sure, but they definitely realized they were not going to be able to afford his services. All right.
But right, I guess you could pay a lawyer $5,000 just to consider the case. Um, but
Right.
if you were ever officially on the case, it seems like there would also be record of when he left. But it seems like he was kind of like in limbo. Um, and yeah, so I'm just again not sure this is going to be quite enough to get some sort of retrial.
Right. And I agree. Well, we don't know if the retainer was found returned or not. There's nothing that said it wasn't. So, don't know the answer to that question. Depends what he did. I mean, does a meeting and a couple emails warrant $5,000? I don't know. It was an email typo that was sent. Let's see here. Good question. Why didn't they ask their own actual client to testify or provide an affidavit of this? Richard Allen himself. Kathy is not a representative of Richard Allen. So, what we know, October 27, 2022, Brett Gibson is retained by Kathy Allen, wife of Richard Allen, and hired Brett Gibson as Richard's attorney. Payment was given to Gibson. She paid $5,000. Gibson letter to the sheriff's department on the same date. Gibson sent a letter claiming to represent him. November 9th, 2022, Richard Allen's letter. Let me see if I can pull that up. Oh my God, I got too many screens open. But I'm opening another one, so just hang in there with me. Okay.
Any word from Greeno?
Said 5 minutes, I'll be in. Oh, let's see here. Here we go. I'm going to move this screen over here. And can I make this bigger from here? No, I'm going to have to download it to make it bigger. Okay, so basically, this is the letter from Richard Allen. And I'm going to make it bigger so everybody can see it. So this was filed November 9th, 2022.
And when was the safekeeping hearing?
It was on November 3rd. So on November 3rd was the safekeeping hearing. November 9th, this was filed. And it says, in the cause listed above, I, Richard M. Allen, hereby throw myself at the mercy of the court. I am begging to be provided with legal assistance in a public defender or whatever help is available. At my initial hearing on October 28th, 2022, I asked to find my representation for myself. However, at the time, I had no clue how expensive it would be to just talk to somebody. Keywords, just talk to somebody. I also did not realize that my wife and I's immediate financial situation was going to be. We had both been forced to immediately abandon employment. Myself, due to incarceration, and my wife for her personal safety. She has had to abandon our house for her own safety. What little reserve there is will fail to even maintain the original residence. Again, I throw myself at the mercy of the court. Please provide me with whatever assistance you may. Thank you for your time in this matter, this most urgent matter. Sincerely, Richard Allen. So, what that sounds like is that she paid $5,000 for a retainer. He initially sent Nick McClelland, the sheriff, and the jail information that he was representing Richard Allen. Okay. But the reason he never filed an appearance is because what is missing from this is the fact that they spoke and he told them how much it would actually be to represent Richard Allen, and they couldn't come up with that money. Does that sound right, Sterling?
Absolutely. As soon as the lawyer figured out like what deep shit Richard Allen was in, He basically aborted. He went back to Kathy and said, "You can't afford this." Yeah,
Or he went back to Kathy and said, "This is how much it's going to cost," and Kathy's like, "I can't afford that." You know,
pretty much.
exactly. So, ooh, I didn't want to do that. I wanted to close that out. So this one here is a receipt just showing the $5,000. That's what I showed you before. Once again, payment. Now we found this, we wanted to throw this in there because we came across this again last night. So it says Ron was never a pillar of the community. Cranky, grouchy, but never mean to any of you. Neighbors, hello. Sherry Mears came to Ron in a panic when he found a guy cooking meth at the cemetery. The guy had pushed Sherry. Ron went right down to defend Sherry. I have more reasons to not help him, but even I know this is BS. I talked to him for 4.5 hours after the murders. He was so upset he nearly cried because he just couldn't imagine anyone doing this. He's lived there for over 50 years, and now you think he's some mad lunatic? Shame on all of you. All of you. Shame on the police for using him and punishing him when they have no reason to suspect him except that it's his land and he violated a DUI probation. His life is ruined because he did something stupid, but it wasn't murder. I know what they were looking for at the farm. They have everything he had already. So find a new subject or get your facts straight. I'm also notifying the news stations. Good to know our right little community sticks together. Um, and then Jeannie Logan posted, I've had enough of this. Ron Logan is not a suspect in the murder investigation. He's being held for a DUI probation violation. The police and his attorney have time-stamped videos of his whereabouts at the time the girls went missing. The hype is coming from the news media and people on Facebook. He is 77 years old. Think of that. He's not even close to the age of the guy in the photo who looks between 38 and 42. Ron is terrified of heights. You couldn't pay him to walk across that damn bridge. He would never walk 3 feet out on it. The voice is totally different. He's not the guy. The police are using him as a diversion because they have nothing. If they had DNA, they would have it by now. They can rush things through Quantico when they need to. And then she says a buckle test, cheek swab, would have been done and over. They are punishing an old man to keep you armchair detectives preoccupied. Another thing, where are all if you who know Ron? I think it's supposed to say, where are you? Where are all of you who know Ron?
Well, it's a big change in topics, from the lawyer stuff to this. But like when they said that they had timestamp video of his whereabouts that day,
Yep.
what do you know about that part? Because I mean, I know like when he went out to the dump or whatever you call it, the recycling center,
Mm-hmm.
there was video of that.
Yep.
But, but what else do you know about that?
Well,
The rest of it.
I know that they had a timestamped video of him being at the sanitation station, but what they have in addition to that is a receipt from the just before he left the fish store, the aquarium store.
And what time was that for? Because
Oh,
I remember it being like 5 something.
yeah, and it takes about a half an hour to get home.
Right. So if it takes half an hour to get there, then he could have left at like what, like 4:30, 4:40. You know.
Right.
So I feel like it's that time in between that I'm unclear on.
I think we're all unclear on it, and nobody has really said where he was.
And I think in the search warrant for his property,
Yep.
there was information extracted from his phone that shed some light allegedly on his whereabouts for that
Right.
day, and that's where somebody said they got the information that he was out there at the crime scene itself at like later on that night, at like 10 something that night. Have you ever heard that, or do you remember reading it?
Yep. I'm bringing up a new screen. Hang on a minute. Because that all was in the probable cause affidavit of Ron Logan's arrest and stuff that we found out later on. Let me find my file here. Oh, I went too far. One second. I'm trying to find it. I have so much in this freaking saved on this case and other cases. Here we go. All right. That is what I just looked at. Okay. Bring this down. So, I'm specifically looking for the Ron Logan information. See, this is what kind of confuses me, is because now this is talking about that Nicole Robertson, who is the FBI agent, and
Okay.
she believes that there's good cause to believe evidence of a homicide is located in the residence of Ron Logan, okay? And describes the house. She's a special agent with the Federal Bureau of Investigation. And let's see here. So she talks about how they're walking down the trail. They're supposed to be picked up by a family member. Suspect has been developed of a white male wearing a blue jacket with the heavy physical build, wearing a cap and blue jeans. Now, on here it says, on February 14th, victims LG and AW were found with wounds caused by a, and blank because they redacted it, weapon, on the property owned by Ron Logan. A large amount of blood was lost by the victims at the crime scene. Because of the nature of the victim's wounds, it nearly certain the perpetrator of the crime would have gotten blood on his person or clothing. The location of the crime scene is approximately 1,400 feet from Logan's residence. Owns farmland, good physical condition. Talking about signs, no, okay, LG and AW had no visible signs of a struggle or fight. So during the processing of crime scene, investigators located unknown fibers and unidentified hairs, which may later be used for comparison. Then they're talking about his weapons that he owns. Then he contacted his cousin and asked him to lie. A receipt from Aquarium World in Lafayette dated February 13th, 2017 with a checkout time of 5:21. So there's your answer, Sterling. Was found in Logan's home.
Right, and if that's all we have is the video where he went to the county dump or whatever you call it, between there and that receipt, I feel like there's a lot of time, and that's really the important time.
Right.
And I heard they followed up on that receipt and they talked to the clerk, and she remembered a guy who bought a lot of stuff. He had gray hair.
Yep.
So I'm not sure if they have that on video, but they did follow up on it. But even still, like I said, there's a lot of time in between that I'm unclear on.
Okay, so he drove to the transfer station to drop off trash. Video from the transfer station shows Logan driving his white Ford pickup truck between 11:27 and 11:32 a.m. The video from the transfer station appears to be off by 26 minutes. So he was actually at the transfer station between 11:53 and 11:58. This is all talking about the girlfriend. Trying to find okay. A call placed using Logan's cell phone produced cell tower data that shows Logan's cell phone appears to be in or around his property on February 13, 2017 at 2:09. Although his exact location cannot be confirmed, the tower data shows that Logan's cell phone was in the Delphi area, in the area of the Monon High Bridge Trail. An analysis of Logan's cell phone data revealed a text message sent from his phone at 7:56 p.m. on February 13, 2017. Initial exam of this analysis indicates Logan's phone was likely outside of his residence and in the proximity of where LG and AW's bodies were located. So my question on this is, how can it be right outside his house but down by the crime scene at the same time?
Yeah, it's unclear. Is like how specific were they based off of pings or geofencing? I'm not exactly clear, and how accurate those are. I'm not clear on that either.
Right.
But
Because
it's
then it says that um his cell phone data revealed a text message received by his phone at 10:16 p.m. Initial exam of this analysis indicates Logan's phone was likely outside of his residence and in the proximity of where LG and AW's bodies were located. So once again, how can it be right out was likely outside of his residence, but in proximity to where the bodies were found?
I'm not sure if it said right outside or just outside.
It was likely outside of his residence.
Right, outside of his residence, in the proximity of where they were found.
Right.
Yeah, to me that would make sense. So it's accurate enough to know like when he was in his house and when he wasn't. Is what I guess it's saying.
Right. But it can't pinpoint exactly where he was.
Right. To what degree? Yeah, we don't know.
All right, let me see. I am looking for.
But it sounds like he was in the general area at the general time of the crime. You know.
Yeah. Now I swear on one of these there was coordinates, and that's what I'm looking for. Here we go. Okay. So in this document, it says on February 13th at approximately 1 p.m., juvenile victims, hereafter referred to as LG and AW, were taken to the Monon High Bridge Trail located in Delphi, and were walking the trail in the area of County Road 300 North near latitude 4035 21.4 and longitude 8638 23.3, which was the last contact with LG and AW by cellular device. So they were found deceased at the above latitude and longitude, having been the victims of murder in accordance with the Indiana Code. So I'm wondering how I got to talk to Frank Meister, because when we went down and put the orange dot on the tree, I'm pretty sure these are the coordinates he used.
And it also says near, right? It doesn't say like how near.
Right. But what I found out since the trial is that where we were showing everybody where the crime scene was on these memorial walks, it was incorrect. We were like 100 to 150 yards away.
How'd you find out?
Because when they showed the crime scene photos in court, the tree that Libby was by was a double tree. So we went out walking in the woods looking for that double tree. And Lauren from Hidden True Crime, her assistant and a friend found it first. And it was the exact double tree that was in the photographs during trial from the crime scene.
Okay, gotcha.
So that's how I knew, because then I walked there with them and I took some video. Hang on, I'm trying to find out what Anthony is up to.
Yeah, he's done this recently a lot. He invites me somewhere and then doesn't show up. I don't know. So this is coming from an individual who pings phones. It depends on a lot of factors. Carrier, last time the phone was used, strength of service to the phone from the tower, etc. Sometimes it can be within a few 100 feet, but sometimes it can be miles. So it doesn't sound like it's very accurate. Well, it depends what you're going by, like pinging a phone versus like if you had their phone and you could get on there and see where they were. Like I'm not sure like what process they use, and which ones are more accurate than others.
Right.
Because I was under the impression like they got the information from his phone, which I'm not sure if that makes it more accurate or not. I don't know.
Yeah. Interesting. So, like I said, we want to find out more information about pings on the phone, and this whole thing with the port. Because the other part of all of this is the affidavit of Stacy Eldridge stating that she's over 18 years old and competent to testify. She received her bachelor's degree in management information systems from Bellevue University in 2001, received a master's of science degree in computer information systems, provide digital forensic and mobile forensic services. So all of these different things. Plus she's saying she has the following certifications. Now she's stating data from Liberty German's iPhone 6X showed that wired headphones were plugged into the phone at 5:44 p.m. Eastern on February 13, 2017, and were unplugged at 10:32 p.m. Eastern on February 13, 2017. This was the only evidence of any wired headphones ever being plugged in and removed from the phone. Okay. Apple iPhone 6s were equipped with sensors to indicate water damage, which I know that my phone does, because when my port got water in it, it gave me a message right on my phone. But that's a newer phone. That wasn't back in 2017. That there was no indication in the data from Ms. German's iPhone 6X that indicated the sensor identified water damage to the phone. I would expect to find evidence of the water damage notification that is displayed to the user to be present on the iPhone. Now, I don't know what she's talking about there, because I just got a little pop up and then it went away. And I never saw anything like that.
I think it depends on what model iPhone you have
Okay.
as to what the sensor looked like and how you could see it and what you had to do to access it.
Okay. So, because then she starts talking about the extraction and the reports produced by the state. Celebrate the logical extraction report and data created by Indiana State Police First Sergeant Brian Bruner on February 15, 2017. And the Celebrate Method 1 through 3 extraction report created by him on October 12th, 2017. And then the digital forensic examination initial report created by Christopher Cecil on August 21st, 2019, and another forensic examination supplemental report created by Indiana State Police on August 18, 2024. She stated none of the above reports or restrictions contain evidence of a dirt or water damage to Liberty German's iPhone 6X, nor did they indicate that it was particularly dirty or covered in debris. I reviewed photos of Liberty German's iPhone 6X taken by the Indiana State Police. The phone does not appear to be wet, dirty, or covered in debris in any of the pictures. No pictures were taken of the phone displaying a message indicating that liquid had been detected. But like I said, that message on my phone went away very quickly. So would it have stayed and been on there when the police got to the phone? I reviewed the chain of custody for Liberty German's iPhone 6X, and it did not document that it was received in wet, dirty, or damaged condition upon receipt. iPhones that have a recent water damage are known to reboot spontaneously, requiring multiple attempts to complete the extraction with a forensic tool. No instances of this were documented or reported by the Indiana State Police. I am currently unaware of any scientific or technological research suggesting that water or dirt damage to an iPhone 6X would cause the phone to inaccurately log wired headphones in or wired headphones out. And that's of why we want to get that's another reason why we want to get an expert.
And what time was it accessed?
Oh my goodness. I got to look back in. Deb, do you remember what time they're saying that the phone was accessed with the jack going in and jack going out? The person that just told me that is a firefighter. But I've got to agree. The phone went through a creek and sat on the ground with a shoe on top of it and Abby's body.
But if it was accessed at like 5:44, someone said in the chat, I mean, that would be well after it got wet, though, right? I just don't feel like it makes sense.
Well, that's why, because it got wet at 5:44 p.m., that's why the defense is trying to state that somebody else was there and actually inputted something into the phone jack.
Yeah, and I would tend to agree because according to the state's own theory, like by 2:32, the phone was still, and that was the end of it. So it seems like before 2:32, they would have crossed the creek and it would have got wet, you know?
Yeah.
So So either way, I feel like it's problematic.
KD, you're wrong there. All right, let me see here.
What did you think about that? That front porch footage of allegedly Brad Weber's van driving by Marv. You know what I'm talking about?
Yep, we talked about that the other night. I think it was 5:45. They're saying it was the headphone jack was initiated with the something plugged in, and then 10 something it was taken out. But okay, so Donna says, I'm sure Libby had a case on the phone, so it should have shown signs of being wet when the case was removed. But because there were no pictures of it, this woman is stating that it was in good shape. We don't know that Ron Logan's phone was at the crime scene location. In the document that I just said, it said outside of his house or within the location of the crime scene. All right.
But yeah, that footage of Brad Weber too at two coming home at 2:44, Marv.
Say that again?
The footage of Brad Weber's van coming home allegedly at 2:44 p.m.
Right.
Don't you feel like that's a problem too? Because I felt like if her phone stopped moving at 2:32 p.m., then that kind of just put it puts a problem in the state's theory, right? That
I
he
agree.
got. Hmm. You agree?
That is
And a
his,
lot.
that is the only piece of evidence out of all of this that I can see harming the prosecution's case. But I also said that I didn't feel that it was going to be enough for a retrial because they had this evidence at the time of trial and they did not use it to impeach Brad Weber's testimony.
Did they try to get it in, but they couldn't, and Gold denied it? Do we know if it was like they tried in a sidebar and it got denied or something?
No, they did not even try to bring this in. Because we sat through all those sidebars and they never mentioned this video one time.
Did they say something to the effect of like, would it surprise you if I could show you somewhere else, at that time or something like that?
Nope. All they argued was the fact that they wanted to bring in people to. They wanted to bring in a detective or something from ISP because Brad Weber said that he didn't go straight home, that he was fixing his ATMs or checking his ATMs. That's all they said. Nothing about a video showing the time difference or anything like that.
Why, but if I could just, yeah, that's where I get stuck because if they had that, why wouldn't they?
Right.
Do you think they just found it after the trial?
Well, if they did, it can't be admitted into any. It can't be admitted for a retrial or an appeal because they had it all along. It was their own fault if they didn't go through the information and find it till after the trial. You know what I mean? It was in discovery this whole time. Does that make sense?
It does. It does make sense. It does make it. Yeah, it does. But it doesn't make sense as to why they wouldn't point to it, which makes me think that it wasn't allowed in there. That's the only thing I can imagine. Maybe for example, they said, "Well, hey, you can't prove what that is. What like it's too fuzzy, it's too grainy. You can't prove it, or you can't prove what time it happened, or something to that effect. So it was inadmissible."
Yeah, nothing was even brought up in the trial about this video. I mean, it would have been the perfect video to play to impeach Brad Weber's testimony. I don't understand why they didn't use it. And none of us remember anything about them asking to play a video to impeach the time. Only the fact that they were wanting to they were showing different documents stating that Brad Weber stated that he didn't go straight home and was checking ATMs and wanted to bring on this witness, but Judge Gull would not let him do it via Zoom. She wanted him to come into the courtroom, and he had other priorities and could not come to trial. So it would not surprise me if, once again, they were going through stuff after trial and found it after trial and went, oh crap, we had this all this time, and now we're going to try to use it for the appeal.
Well, okay, even if they just found it, right? Do you think it's exculpatory nonetheless?
I think it would have been the perfect thing to use during the trial to impeach his testimony. But because they didn't have it, didn't know about it, whatever, it's not considered new evidence because it was in discovery the whole time.
No, I get that. I'm just saying for you personally.
I think this raises some kind of issue because of the way that the prosecution presented the timeline. And the fact that the girls died at 2:32 p.m. and Richard Allen's confession said that he was on the south side of the creek with the girls and got interrupted by a van coming down the driveway and forced him across the creek. And if this shows that he didn't get home till 2:44, there's an issue there.
Right, right. That's how I see it too. Because I don't see a way he could have come home at 2:44 and spooked Richard Allen, and then also account for the time the phone stopped moving.
Right.
Like it seems like it's got to be the way the state said it, or it's just not right.
No, just me. It does not state why the camera was reading AM and 12 hours off.
Whose cam was that, Marv?
It was a camera. It was a camera at one of the houses. I'm just going to bring up the document to show for the address. Okay, it's stating that oh, nope, that's the wrong one. Looking for the big long document. Sorry. That's the little one showing the video. Okay. Let me show you this. So it's a recording made by a security camera that was at the house at 5998 West County Road, 252 North, which they're indicating it here in the red circle. So it's the last house here. And over in here is the private drive. No, Andrea, I am not right now. This thing is so touchy when I make it bigger. So it says it's got a wide security camera that has a wide angle lens that captured video of traffic on West 252 North County Road and 625 North and the beginning of the private drive to the Weber property, which as indicated by the end of the arrow in the Google Earth map below. So right here, they're indicating is the private drive.
Okay. So it's somebody who lives either on or, I guess, near the private drive.
Well, it's down the road and around the corner. That's why if you watch the video that we did the other night, we played the videos they gave you, and it's so small, you can barely see the van. So it's far away.
Right. Did you see it when they zoomed in on the van or the alleged van?
Yeah, I saw that.
I mean, was it compelling to you that was a white van, or what do you think?
Yeah, I thought it was a white van. Looked like a van. Do I know that it's... My first thing was, how do I know that it was Brad Weber's? But we'll see. I think that there was no other vans between 2 to 4, and that it had to have been Brad Weber's. So looks like they proved that it was his van.
There he is.
It was Brett Weber's van.
Yeah, at 244, right?
Don't know. I mean, yeah, it could be, I guess, but it still doesn't change the fact that Richard Allen is the guy that killed him.
Well, if it was 244, it kind of changes a little bit, doesn't it? At least,
No,
I mean, it doesn't.
That's what they think based on what he said. But what if he didn't necessarily tell the truth fully? You know what I mean? Or, I mean, how would he know what time it was? Did he look at his watch and say it's 2:30 and Brad Weber's on his way home?
Well, you're talking about Richard Allen? No, he said he saw the van and then crossed the creek, and that's when it came to an end, right? And if the phone stopped moving at so if the phone stopped moving at 2:32, and Brad Weber didn't get there till 2:44, it just doesn't add up. It can't, right? That's the whole issue.
Well, then that means Richard Allen is not telling the truth on his story on how that exactly happened. He took him over there before 2:32, and then he saw the van, and that's why he left. That's my guess.
Okay. Mm.
And yes, you have to cross the creek to find the bodies, to answer that question. So yes, so I can't hardly hear. Am I on? It must be on a weird delay or something.
I can hear you.
Okay.
But people in the chat have been saying.
So I mean, like,
go ahead.
My audio is what?
No, people in the chat have been complaining about me and Marv's audio all night. So you might. I don't know. I don't know what's going on. Where were you?
It must be. My computer was rendering a video and I couldn't stop it. So it's like right now it's being slow. So it's like it just takes freaking forever for that thing to finish, and we can't stop it, you know. And it's like if I come on here, I'll just be glitched up the whole time. So it says he didn't know who was driving a van. He just knew I'd hide them so I don't get caught. That's my guess. They said he saw a van, and that's why he told Walla that he said a van. Okay. So if he told Walla that, he never said he saw a van on one side of the creek while he was standing there. He just said he saw a van and it spooked him, and that's why he left, or he killed him and he left. What if he had him over there already and he killed him because he saw the van and then he left, but he was already on the other side of the creek, is what it sounds like happened.
I don't think you could see the van from the other side, and it clearly said that. I think it said he was like on the south side of the bridge when he saw the van, and then he got spooked and made them go across. So that's what the state said.
Oh, that's what their interpretation of what they think happened is, but they might be wrong on that. It might be he took them down below there to assault them, and he was down there with them for about a half hour, which would make perfect sense on how much time he would have had. He would have had 30 minutes with them, almost from 2:13 when you see the picture of the bridge guy to 2:44. Then he takes him across the creek, and then he sees a car across the creek, and you can't see it from there. And that's when he freaked out and he killed him, and then left, put sticks on him, and then left.
And if the video is off by half an hour, or I'm sorry, 12 hours, how do we know it's not off by minutes either?
It could be.
Because
why didn't they present that evidence in trial?
Right.
Maybe they tried.
No, I'm telling you, they didn't try. I was there. They did not.
They could have asked him. They could have asked him. They could have shown that to him. They could have said, you for sure you got home at 12:27 or whatever time, or 1:27. Okay, well, how come this shot right here has you delayed 15 minutes? Okay, that would throw them for a loop. That would have possibly influenced the jury.
Right, I agree.
To wait on that, what is the strategy there? Because before sentencing, they were already talking about they were ready for a second trial and some of their motions that they were filing. So they were already prepared to come in here and do this exact thing before sentencing.
And Victoria makes a good point. The state just argues what they believe evidence shows. Judge tells the jury this in the instructions. And the state had the video. Because it was sent over in discovery.
Yeah, and they didn't present false information. They gave them everything that was given to them throughout the course of the investigation, and the defense said that they had to go through it.
I thought I remember them saying something to the effect of, "Oh, well, would it surprise you to know that you're on video somewhere else or at a different time?" And then maybe there was an objection and they couldn't present it. But
no, that's why I think that they didn't know that this was all in discovery till afterwards.
I think they knew. I think that they just were looking for a reason because they knew dude was going to get convicted. I think they're just trying to incite public outrage between conspiracy theorists and get people to freak out and to the point like somebody does something like to get him out of there, like the governor or somebody, because they really will believe that he's going through all this innocent, or he's innocent until guilty, but he's already been proven guilty by a jury. So, I mean, that's due process. How come people can't accept that? That's the way the court system works.
Right.
You know, I mean, that's just my thought. I mean, I don't think Richard Allen's going to get a new trial at this, guaranteed.
no, I wouldn't think so either.
Well, especially since the fact that they did not offer this as evidence in the trial. You would have to have new evidence. This is not new evidence because it was in discovery.
Correct. It's new evidence for the public to know.
Right.
That's it. Stuff the victim already knew. You know, and I just go back to like look at the history of the defense team and the things that they filed. And they filed the whole report on O's, and these guys were a part of the murders. But they already had documentation from law enforcement that said that they had cleared those guys. So it's kind of misleading the way they do things. If anything is ineffective, I would definitely say it's the defense counsel as well. You know, they should have remained off the case in March.
I agree.
Yeah, Supreme Court made a mistake, I think. I mean, they upheld the law and the Constitution, but I think that was an ultimate mistake on this case with all that.
And from what I've researched, the only reason the Supreme Court allowed the defense attorneys back on is because there's other actions that Judge Gull should have taken before just removing them.
Correct. And Richard Allen signed that letter saying that he wanted to keep them, which didn't make any sense to me because, I mean, originally they were like, he's too incompetent to participate. As, you know, within his defense, he's too incompetent. He's not able to do that because he's going through all this. But then turn around and have him sign a notarized letter saying that he knows exactly what's going on and that his attorneys, he needs them and all this stuff. That doesn't make any sense to me. That's like a double-edged sword. You know what I mean? Like, that's just what I think on that.
Even if they were going to present this when the FBI agent testified, because Brad Weber vehemently stated in his testimony that he went straight home, they could have shown this video to impeach his testimony, even without the other witness.
Yeah. And you know what? Like, I mean, when the FBI, I mean, I was there when we saw that guy on the stand about interviewing him. I mean, did you think he was a suspect? No. Did you think he had anything to do with the murders? No. You know what I mean? Was there any evidence indicating that he hadn't? No. You know, like, I mean, no was the answers. You know, Brad Weber was not a participant in this. which we found out later on, throughout the process of trial, that he was actually a witness, kind of. I mean, I guess he was there, and that placed him in an area where Richard Allen had said something that also placed him there. And without them two talking to each other, they wouldn't have known that, because Brad Weber this entire time did not know that he did that. Does that make sense? Like, Brad Weber didn't go in there knowing that he scared off Richard Allen, because he didn't see him, or he probably would have called the cops if he saw what was going on. I must be froze or something.
No, you're not froze. We can hear you.
Okay. Weird. I'm not sure what's going on with it. All right, there we go. I just wanted to make sure I was froze. Can you guys see me as well?
Yeah.
Okay. All right. It must not be glitching up on your end, but on my end it is. Okay. So, so what is your guys' thoughts? What all did you guys cover the attorneys and who's what with that?
Yeah, we covered the attorneys. We covered and I kind of threw the jack in the phone in because, like I said, we want to talk to an expert on the iPhone about, would the extraction data show that the message came up showing that the phone was wet or something like that? What exactly would the extraction data show?
Why don't we ask the legal assistant things and see what it comes up with? So,
and let me ask you this:
so
if the results come back that water or dirt couldn't activate that, then what does that mean in terms of this case to you guys?
What do you mean nothing? It wouldn't mean anything to me. So what, you're saying that for sure that someone would have stuck a headphone jack inside of it?
Well, it seems like y'all are interested in finding out from the expert as to whether or not water and dirt could cause that reading, or the same reading that thinks that someone's plugged into the audio jack. And what I'm saying is, what if they confirm? Yeah.
What if they confirm that the audio jack was plugged in?
Well, what if they say, yeah, it's possible that water could trigger that same code, and then and then what?
So then we assume that water did that.
Okay, or that it could have.
Water does that. Okay, then I would most likely take their word for it if they're an expert in that field and know all about like damaged phones and like repair process and what happens if the phone does get dirt in it or is underwater or broken or anything like that.
And what if they say
that's why we want to reach someone?
Yeah, and what if they say that water or dirt couldn't cause that? Then what does that mean about Richard Allen?
I wouldn't say anything. It means okay. So it means one of multiple things that we wouldn't know. One would be some other person than Richard Allen, Abby, and Libby accessed that phone and did that for some unknown reason and then put it under a shoe, okay, after they were done with it. Or it means Richard Allen went back to the scene and did that on purpose, okay, for some unknown reason that we don't know. Maybe he was looking for the recording of himself because he noticed that they had the phone. Or it's Abby or Libby, one of them survived or woke up or maybe became conscious enough to try to utilize it and make a phone call, and they succumbed before that happened.
Or it was dirt,
or it was dirt and water or something that triggered it. Maybe blood. Who knows? It's a possibility that could have been a factor as well because she's on top of it.
And I don't see anybody going out there at those times with all the searchers because they would have had to use a flashlight at that time of night. And somebody would have seen the flashlight in that area.
Or they may have been a lot of flashlights
Maybe.
out there, and they mistook them for a searcher, right?
Nobody searched that
Yeah.
area.
That they know of. Okay, so if no one searched that area, then that means Richard Allen could have went back there undetected. If he was there, and you know how you can click your flashlight on just every little bit, right? And you think about all the other people's flashlights in the area, you can see where they are. And if you have yours off, you can still see some light, but you can also tell where people are at, and you can hear them. So if he was down there screwing around,
nobody was close to that location that night
that we know of, that was seen.
They said there were no lights in that area. Nobody searching in that area.
Right. But Richard, if you were the killer, I wouldn't want anybody to know I was there either. I would try to get in and out as quick as possible.
How are you going to get in and out of there without lights with that terrain?
You can, but because you can just flip it. You can flip your light on and off every once in a while and see. Like with other people's flashlights in the woods, you would be able to see because they're up high and you're down low. So they would, and they had the woods illuminated that night with that big light from that truck. Do what?
But not that section of the woods.
No, but I'm saying that I think that I could go out there successfully at nighttime and navigate straight to the crime scene with no problem. I think I could do it in the pitch black without a flashlight.
You're crazy, not in that terrain.
No, I do. That's a good thing to test because you don't think that that's possible, and I do. So that would be a good thing to go out and actually do it and see if I'm right, or if I do have to have some sort of lighting, you know what I mean, to guide me most of the way or some of the way, and how much I can do it without being noticed, you know? So like, I would pretend, obviously there's a whole bunch of people in the woods, but I would just see how quick I could get in, stand around for a couple minutes as if I was doing something, and then out without a flashlight. And
there is no way with all the tree branches and roots and everything that is littered on the ground, there is no way that somebody is going to walk in there in the pitch black and not hurt themselves. And all the hills and everything else. No way.
And they're not saying he just sneaked in there for a minute or two. They're saying he plugged in for some hours.
Hours? Okay, no, that didn't happen. If that's the case, then it's definitely caused by damage. If it was hours that thing said it was plugged, so what? Someone went down there and listened to music for hours?
That's what I'm asking you. You were saying maybe it was Richard Allen who went back, and I'm like, he went back for 5 hours amidst all that?
Right.
Oh, yeah. So how long? It was 5 hours that it was supposedly
5 hours
with or whatever?
Supposedly plugged in.
Okay.
Yeah,
that
from
tells
like
me enough right there. Case closed. It's damage from some other element, not a person. It's damaged. No one went down there and plugged a headphone jack in for 5 hours and stood there while those people were searching. Nobody in their right mind would do that. Not the killer, not someone who found him and just was scared. Nobody would do that. Nobody would do that. That's too risky. I mean, you're just sitting there waiting for everybody to show up and get you.
So I'm here to tell you.
If they show up in your hand, you're holding a phone with a headphone jack in it, belonging to the victim, and they're dead. That's a wrap for you.
And you got to realize this is all about the port. Okay. So when my port got wet, I got a message that said that the port had water damage in the port and that it would not charge. My phone still worked though. Everything about it worked except for the fact that when I tried to plug the cord in to charge the phone, that would not work until it dried out.
I also have a question on what you guys think about the motion to correct errors. So the thing that brought all this out, the timing of the filing here is odd to me because, depending on how law works, in Indiana, which I'm going to try to look up or find out from we can ask the co-pilot or whatever. I don't know if these are going to be granted simply based on time relevance in filing motions, especially after a conviction. So I think that they would have had 30 days from the date of conviction to file a motion to correct error. And I think that should be stated within the judge's order at the end of trial. So I'm going to look on my case on my phone and see if I can find what it said in that final motion and when they actually filed it, because they may be out of their time limit to be able to file a motion to correct error by just 30 days. So they would be off by maybe 1 or 2 days, depending on when they filed that and how many days had passed in between there. So here's one thing to find out.
I think they're actually right in the deadline to do it with the presidential election and everything. They're going to take off add some days.
What do you mean with the presidential elections? So that would have been, we were in trial on that day. Okay. So that was the day of trial, right? Or we were in trial that day. So, hey, he didn't get convicted until the 11th. So that would have been afterwards.
Yeah.
So, you know what I mean? So that wouldn't play a factor into it, but 30 days from the date of sentencing, that would have been December 18th. What's 30 days from that? The 17th of January? Because you have 31 days. Okay.
Yeah.
They didn't file this document until, let's see, when did they file this document? And Marv, you should look that up on Copilot and see what the time frame is.
Is when all this was filed.
January what?
20th.
January 20th. Oh, December 20th. I mean, okay, so December 20th was sentencing.
And this was filed.
So December 20th. Okay, well, they're 1 day late, I think, because there was 31 days in December.
What do you want me to look up on Copilot?
What the Indiana statute is regarding file a motion to correct error after a conviction in a jury trial. And I'm looking up the other document right now, everybody. So, see if I can find it. Okay, so they filed a motion to correct error. It says on the 20th, yes. Now, did you go through those documents I sent you about the attorneys as well?
Yeah.
Yeah.
Okay, what did you come up with that, Sterling? I'm kind of curious. Like your conclusion. I mean, who was the defense attorney? Brett Gibson, Andrew Baldwin, Brad Rosie, and where's the misconfusion there?
Oh, right at the beginning where the safe housing hearing, is that what you're talking about?
Yeah.
Well, yeah, and I mean, who are his attorneys?
Well, at that point, I'm not clear he had one. So I'm not sure his rights were violated. And even if they were, I was telling Marv that I'm not sure it's a critical stage of the case. So either way, I think they'll get around it. I don't think it'll be grounds for an automatic retrial, even though certain lawyers have been on YouTube saying that it would be. So I don't know.
Like Michael Ausbrook, right? He's the one saying that would.
No, a lot
guaranteed.
A lot of them are stating that. Even outside this case, they're stating that. Okay, so
stating what?
Stating that he should get a retrial because of that.
But that's not what was required by law. So,
right. So it says the motion must be filed within 30 days after the entry of a final judgment.
Okay, so she entered an entry of, let's see if we can find it. I'm looking for it. So we see, we're looking for the order that was issued on the day of sentencing to see if we can find that. So Richard Matthew Allen and we're going to look through the database and see what we can find. So sentencing was December 20th. Yes, you're right, Tammy. So I just want to know.
When did she actually file the sentencing verdict?
Well, it's whenever it was signed and stamped. Yeah.
Because it says 30 days after the entry of a final judgment.
Right. So entry is whenever they put it into the database after court, which they did almost every single day at court. Every day at trial, she would enter an order on that day's judgment, and it's dated in there. So that's what we want to know.
Right.
That'll tell us, the most information on whether or not she's going to deny these motions based on improper filing time. So weekends and everything, it's 30 days exactly. It's not, they don't discredit the weekends, only federal holidays. Or holidays when the court's not in session. Okay, so they filed that on the.
So yes, the 30-day
concurring
motion to correct error in Indiana includes weekends and holidays. The countdown starts the day after the entry of the final judgment, and every calendar day is counted. However, if the last day falls on a weekend or a legal holiday, the period extends to the next business day. So you don't need to rush to the courthouse on a Sunday if your deadline happens to land then.
Okay. I'm going to send this to your Facebook. This is the order entry. And this is what we need to read here.
Not according to what I just read, Andrea, because it says the 30-day period for the filing a motion to correct errors in Indiana includes weekends and holidays.
Right. So there you go. So yeah, it's just straight 30 days. Like from that day on, like there's no stopping for New Year's or anything. They got 30 days. So in this order that I sent, this is the final judgment order from trial. And I sent it to your Facebook, so you should have it.
All right, hang on.
It says in this, okay, you can pull that up. I'm going to start reading it for everybody. So it's in the judge's handwriting. It says, defendant appears in person and with counsel, state by prosecuting attorney and deputy prosecuting attorneys having been found guilty following a trial by jury. Sentencing hearing is held. The court, having considered the pre-sentence investigation report, the sentencing memorandum submitted by counsel, the arguments of counsel, and having heard and considered the evidence at trial, now finds the defendant guilty of murder in counts 3 and murder in count 4. Court finds aggravating circumstances in the nature and circumstances of the crimes, multiple victims, extraordinary impact on the families of the victim. Court finds mitigating circumstances, the lack of criminal history, and the defendant's mental health history, although the court finds no nexus to the crimes committed. Okay, so there's no crime between his mental health and then him committing the crimes. Defendant ordered and committed to the Department of Corrections for a period of 65 years on count 3, 65 years on count 4, consecutive 130-year sentence, 786 days jail credit, public defender fees, $200 assessed with court costs. Defendant advised of his right to appeal and indicates he wishes to appeal the circumstances and sentences, but cannot afford counsel. Court appoints the state public defender. So they perfect appeal. Till they perfect an appeal on defense's behalf, gag order now lifted and the case concluded in trial court. Convictions on count 1 and 2 are vacated due to double jeopardy law. And it is dated on, let's see, where's the date for this? December 20th, 2024 is when it's signed and dated. So that's on. So there's the final entry. And it says order on judgment of the court. So that's the one. Yeah, it's handwritten. So they handwrite orders just like they always used to do. Like during court, the judge makes notes. They used to have it all in Carroll County like that. But Carroll County's got pretty basic templates.
Okay, so according to this, it says the final judgment was entered on December 20th, 24, and you would need to file the motion to correct the error within 30 days. Start counting from December 21st, 2024. Adding 30 to December 21st, 2024 would bring us to January 20th, 2025. So they got this in on the very last.
The day after.
Huh?
So it was the day after. It was the day after she entered the order.
Right.
Yeah, but
Is when it started.
Greeno, it said something about 30 days from the day after that it was entered.
Yep.
So instead of the clock ticking on the,
they get it right on the.
So they got it in on the very last day.
I was looking for a way.
So they met.
Or maybe we can just convince people this actually on 19th. Our timing's off on our timeline.
What's that?
I said maybe we can just do what they do, and we'll convince everybody that it's actually the sentencing happened on the 19th, and that the timeline was just a little bit off by a day. And see what they say there. So I feel like you guys can't hear me that well, or like I'm really glitchy or something.
You cut out every once in a while, but
okay.
No, I think they got it in. They got it in at the buzzer, like, right the last day. But nevertheless, this goes to goal, right, to make the decision.
Yes. Well, yeah. On those, I mean, yes, on those.
And I'm not sure.
But I'm not sure either, man, because here's what happened is like, okay, so that day so this is what happened with me as well. There's question here is what I have. And I know this just based on experience, because the last time I was in jail, I filed an appeal and the same thing happened to me. So I was found guilty and I was asked if I wanted to appeal the sentence. And I said, yes, I do want to appeal the sentence. And the judge said, I'll now appoint the state, public defender or whatever to represent you on an appeal, because I had my paid counsel, Curtis Fouts. But then once that case was concluded, he was no longer my counsel anymore. And so I would either have to pay him, but he's not an appellate attorney, or try to find an appellate attorney, which is almost impossible if you're in jail and trying to make phone calls to people. So I took the public defender. And once I'd said that day, my counsel was withdrawn from case and I had a new attorney. So anything that Baldwin or Rosie is filing is potentially is moot, null and void, because they're not the attorneys of record anymore. And it says in that order that she appoints a new public defender. So, I mean, are they just doing this just to do this? Or to try to help the other attorneys that are taking the case? Because one of them's already worked on it before. He's already hit the game.
So I asked them, if an attorney had a video from discovery and did not use it during trial, can this be used on a motion to correct errors or an appeal? It says yes. If an attorney had a video from discovery and did not use it during the trial, it could potentially be used in a motion to correct errors or on appeal. According to Indiana Rule of Civil Procedure 59, newly discovered material evidence that could not have been discovered with reasonable diligence before or during the trial can be grounds for a motion to correct errors. However, it's important to note that the evidence must be material and not merely cumulative or impeaching. The court will consider whether the evidence could have changed the outcome of the trial.
I don't think it would have changed the outcome. I mean, I don't know. I don't think that would change the outcome.
It's hard to know without hearing from the other juror. We only heard from one juror.
We have to hear from everybody in a consensus. They would have to agree on every single topic that we asked. You know what I mean? In order for that to be conclusive, to say it would affect the rest of it. Because if you also go back and say, okay, well, if we would have done this, the state would have also responded with their response to that. So, and we don't know what that could be because it didn't happen. It's just hypothetical.
Right.
Right. So, I mean, it would change a whole lot. I mean, if you went right instead of left, it would change a lot, you know?
Right.
So, I mean,
they have to have this motion to correct errors before they can do the appeal, I believe.
right.
Right. It's part of the pre-appeal sort of process.
This is all just standard stuff.
Well, I've also heard that, whether or not they should have brought it up, the defense team, what I've heard is that because this was in discovery, McClellan should have known about it, and he allowed Weber to give false testimony, and he himself should have corrected it. And I've heard that that's part of it as well.
Okay, so it says in Indiana, you generally do not need to file a motion to correct errors before filing an appeal, except in specific circumstances like newly discovered material evidence, alleged jury misconduct, or certain procedure errors. In these cases, a motion to correct errors must be filed and ruled upon by the trial court before you can proceed with an appeal. For most other issues, you can go directly to the appeal without needing to file a motion to correct errors.
Okay. That's pretty interesting.
Yep.
So this is Microsoft Copilot that we're using, everybody. It's a API agent designed to speak back and get information and help conduct research and compile pretty anything and everything that you want it to do. I mean, we'll ask it this question right here. What is considered? What did you write? Can you zoom in a little bit? We can kind of see it, but it's a little bit.
It won't let me zoom in.
No, there's no. Okay.
Material. I said, what is considered material evidence? And it said material evidence refers to evidence that is relevant and significant to the issues in the case. It has the potential to influence the outcome of the trial. Here's some key points about material evidence. Relevance. The evidence must directly relate to the facts in dispute or the legal issues being considered. Impact. The evidence should be strong enough to potentially change the verdict or judgment if it has been presented during the trial. Non-cumulative. The evidence should provide new information, not just repeat what has already been presented. Authenticity. The evidence must be credible and reliable. Material evidence is crucial because it can provide new insights or corroborative existing claims, thereby affecting the court's decision. So that is what that says.
What does it know about
Ask
getting ask it what?
No, I was going to say, ask it what the probability is of Richard. Well, I guess we'd have to submit documents to it. So that I'll do for like tomorrow or something like that. I kind of want to know what it thinks the probability of Richard Allen receiving a new trial based on factual evidence, and information currently, like what it actually thinks about that. But I mean, I think for it to get a better understanding, it would need the court documents submitted with it. you know what I mean, the correct errors, and then all the information from trial to be able to fully understand what it's looking for. Because right now it's just going to browse the internet, and what's the internet full of? The media saying Ron Logan confessed, which he never did, and that Richard Allen is innocent, pretty much, which he was found guilty. But what do you think? What was you going to say?
Well, I was going to ask, was there anything compelling in that Ron Logan alleged confession that, persuaded you to think it might be real? Or was there anything in there that made you think, oh, this couldn't be real because this doesn't add up?
Pretty much none of it added up. Only one thing hit a coincidence, and that was the boxer type deal, right? But other than that, the stories didn't line up to be Ron Logan said that. One, the dude failed a polygraph test. Two, they took him as not credible at all. Based on what he said, going down a hill, a gun, crossing a creek, seeing the van, anything. He didn't mention any of that stuff. He just said that the oldest one and the youngest one had this story about walking with him from the trail to his house, and they would have walked through a creek if they went down the hill and through that way, and unless they were on the other side of the bridge and walked that way, which we know didn't happen. So I think the dude's story doesn't add up at all. Why? What do you think?
Well, I'm not sure if it does or not. I thought one thing was weird was how, allegedly Ron Logan referred to the girls as the younger one and the older one. And, because there wasn't that much of an age difference between the two.
Right.
You know what I mean? Like, I'm not sure if you met them. Even if you asked them what their age was, and they told you, like, I'm not sure you would go on describing the young one and the older one, as if there was some big difference to an old man.
And he could have gotten that information. Exactly. And he could have gotten that information from watching the news reports, because they kept telling the ages of the girls.
Right. I think it would be more likely.
Yeah, 13-year-old Abby.
Yeah. It would be more likely that you described the bigger one, the smaller one, the one with blonde. You know what I mean? Something more like that.
What would I be wrong about on this filing here? I'm kind of curious here. What would be wrong about what I think about that? Which part? If you're trying to say that, like, maybe the time frame, yeah, I was wrong about that.
What about the time frame?
But the time frame on that filing, I thought that they were past the time, but I didn't realize it was the next day that it started. So I'm pretty sure Logan could remember the names. I mean, he knows exactly who they are. I've talked to him, and he knows who they are. He knows this case well. Other people have talked to him, and he didn't call him the younger one and the older one. And there's secret recordings or whatever, so he didn't know he was being filmed. So I don't know. That dude's story it wasn't good enough for me. I mean, it was kind of like that one guy's story that called into my show and said that he had killed him or whatever. His girlfriend put his DNA at the crime scene, and he burnt her up and all this stuff. And ironically, his name was Daniel Pearson. So his story didn't add up either. Apparently, because law enforcement looked into him the very next day, and that was over with real quick. He was in a hospital in no time.
And he said he knew one of he said he knew one of the girls' fathers, right? Which doesn't mean that he did truthfully, but I didn't know if there was any evidence that part was even true.
Yeah, I don't know.
And he may have known. He may have known the families, the adults in the family, but I was told that he did not know who the girls were.
Also Keegan Kline said Tony did it. Do you believe him? Everybody? I mean, people say I did it. People say the sheriff did it. people say, a whole bunch of people did it. I mean, how come we don't believe them? When it comes to that inmate guy, I mean, people use that against people a lot. Like, well, you couldn't be credible because you have a criminal record, but you'll use an inmate in prison for 50 years as a credible source. And that's a little bit, you can't really do that. You can't do it both ways.
And like we talked about the other night, he failed his polygraph.
Yeah, case closed for me. That's enough and apparently it was enough for law enforcement. So now the attorney's thing that we were talking about earlier, did it give you an answer on the probability, or did it tell you?
It just said the probability is difficult to predict. The defense had raised several significant issues, including alleged false testimony, newly discovered evidence, and procedural errors. These factors could potentially influence the judge's decision to grant a new trial. However, it ultimately depends on the judge's evaluation of the new evidence and whether they believe it could have affected the outcome of the original trial. The legal system can be quite complex, and outcomes can vary based on many factors.
But what if the inmate, what if he would have passed that polygraph? What would you think then?
Then it would be a different story for me. I would think more into it, but I'd want to know more details. I'd want to be like, okay, well, tell me again what happened, exactly how they did that, or how he did that, and poke holes in that story and see if you can, because in everything, what I try to do is find the hole. Where's the missing piece at in this? Debunk it as much as I can. And if I can't debunk the person, then that's the person, so, or that person would actually have some information. So some of the people, you can figure it out, I think. I mean, it didn't take long to figure out a bullshitter.
Well, yeah, because there are other confessions in this case that are corroborated by people who took polygraphs. But I feel like go ahead.
Who, like Elvis Field's sister?
Yeah, for one.
Well, that just means that she said that he said that, but the evidence shows that he wasn't there. So, and that they both have very serious mental health conditions, both of them. And both are on really a lot of medication too, that the officer saw and witnessed. So, I mean, how do you take someone that has the mentality of a 7-year-old that supposedly says something to his sister that she reiterates that he did say, but he's not really competent to stand trial in the first place? So, I mean, that's where it comes hairy for me, because I mean, the guy really wasn't competent enough to be tried anyway. You know what I mean?
What was the evidence that he wasn't there?
He was on a video surveillance camera. Like, if you go through their police reports from Rushville, you can see where their conclusions had come up with, like where they saw these people, what they talked about with these people. Now, granted, Click was arrested, but there was still those 2 other dudes working on the case too. So I'm sure that they would concur in that investigation. What's his name? The one guy who died, and the other dude. Click and Ferenczi, and I don't remember what the other one's name is.
I don't ever remember his name either. I've got to get going here shortly.
Okay. All right. You can take off if you want. I can hold it down or whatever for a few minutes since I was late coming on here.
Okay, so tomorrow's Sunday. I can't do a live, but Monday, do we want to do our live chat with everybody? Call in. Other creators can come on.
I was going to do one tomorrow. I was going to kind of do just a me session tomorrow as well. So yeah, I think that we could do that kind of both days, because I was just kind of wanting to jump on here and talk about just my personal thoughts on all this stuff and everything, like just the whole case and stuff, and kind of where it's led and where I'm at today and what I'm doing and where I expect my channel to go. So yeah, I think that I'll do that tomorrow, and then Monday we can jump back and we can go over other things. And Monday, hopefully, we can at least get a hold of somebody finally about the phone deal.
Hopefully, crossing my fingers.
I'm hoping that someone gets back to us. So I did ask a couple places. I had the thing send out a couple of emails to different people to see if there was someone that could give a comment on that. And so far, I don't have anything back, but it is a weekend. So that's the only thing I can think. Yeah. So that's pretty much it. So, all right. Well, I mean, you can take off if you want, and I'll be right here with Sterling to hang out for.
Thanks for answering all my questions, Marv.
Oh, you're welcome.
You're really good and organized with like all your files and documents, because like anytime I asked a question, you went straight to the document and found it. So yeah, I really appreciate that.
So if you take a look at, oops, hang on a minute. So if you take a look at my chaotic mess here, this is my external drive, and I have all of this stuff to sort yet, and there's a lot. I mean, there's screenshots, there's pictures. It's not just from Delphi, it's other cases. I mean,
use Copilot, dude. I'm telling you, use Copilot. Tell it to make you a spreadsheet, get that list, and you can actually have it do that for you.
So
literally,
what I've done is I created a cases folder for right now to put everything in, and I've got all my different cases up in there. And Delphi is huge because I've got pictures of just Abby and Libby, documents, crime scene photos, German family pictures and screenshots. I mean, there's tons of stuff in here, and I got more to put in there. So, and then I've got Keegan Kline newspaper articles, Ron Logan videos, Westerman, and then the Williams family. So I'm trying to get organized.
Of Ron Logan?
Yeah, I got a Ron Logan.
Of Ron Logan?
Yeah.
Gotcha. You know what? Actually, I'm gonna go ahead and cut out too, because I'm gonna go get something to eat. But yeah, I'm gonna go ahead and cut out as well when you cut out. I also need to get back onto. So I just finished an episode of like Murder on the Monon, like fully rendering it, and that took freaking forever. I mean, forever. But it's done. And earlier I uploaded an intro for us to use tomorrow, and I'll use it for the outro today if I can. I think that I can do it today.
Okay.
This is okay. You may like it. I don't know. It's talked about previously. But anyway, so Sterling, you want to join?
Yeah, in a minute. Just want to say thank you to those that donated through PayPal. I did get that, so thank you very much.
Yeah, and you know what? I want to say thank you to the people that donated to me through PayPal and Cash App. The last couple streams or whatever. I don't really stream a lot, so I switched over channels. This channel is not monetized at all, so it's really just solely dependent upon those kind of donations at PayPal and Cash App. So if you guys want to do that, you can do it in the description. All of our links and everything are in there, as well as our affiliate accounts, which I'll talk about when Marv jumps off, because I'm supposed to do that. So I'll just tell you guys about some of the things that I'm doing and using, and tomorrow I'm going to give you kind of a more of a detailed explanation on what I'm actually doing now and what these affiliates are doing, and kind of why I'm supposed to tell you to go check them out. So that's what we're supposed to do when we get into affiliates.
As far as Beyond the Evidence, we will be back on Sunday to do a call in, answer questions. I'll see if I can get some people to come on the panel in case I don't have the answers, and then we'll go from there. And then I'm gonna start new stuff. So after that,
Thank you, Marv.
Okay. All right.
welcome. So
There you go. And sorry it took so long.
yeah, everybody have a good night. For me, remember, justice matters to all the victims and their families. And Sterling and Anthony will close us out. I'll see you Sunday.
All right. We'll see you later, Marv.
Bye.
Later.
Cheers.
All right. We'll be right back. We'll be right back, everybody.
Hello, everyone, and welcome back to Beyond the Evidence, the podcast where we dive deep into true crime cases, uncovering the facts and exploring the unanswered questions that keep us coming back for more. I'm your host, Marv, and I want to thank you for joining me today. If you haven't already, please subscribe to my YouTube channel and hit the notification bell so you never miss an update. And if you'd like to support the channel, you can find links to my PayPal and Cash App in the description. Now, let's get into today's topic.
In the shadows with
All right, Sterling, are you here?
Yeah, man.
Okay, I'm here. All right, so, what's going on, man? What's on your mind?
Well, you always invite me somewhere. You're like, yo, come here, and then you don't show up. You know.
And I know, dude, it took forever. Like I kept telling her, I was like, hey, man, I'm stuck here. Like I can't come on until this. And I don't like to do it from my phone because I can't see from the phone. You know what I mean? I just can't see. And it drives me crazy. So let me switch up this thing right here.
Well, it just seems like.
All right. What, like
yeah,
I skip out on you, son? Like you skipped out on me after sentencing?
No, we didn't talk for a long time. I just needed a break. But it seems like you're trying to get an expert to tell you definitively about that audio port jack. But I don't see how it'll change your mind about anything one way or the other.
Lose all signal here. So I grabbed my phone really quick. All right, so Sterling must have cut out. So see, the moment we started talking about that, beep, I dropped my vape, okay, hit the computer and froze the screen. How the hell does that happen? Look at my screen. Beep. That easy. There it went. Gone. So I am, not yet. I am just here. I just wanted to let everybody know I am back. I told you I'd be back. It just froze the screen for some reason. So I just wanted you guys to know that I'm putting a lot of time and work into, what I'm doing on learning how to use some of these new computer programs and stuff that we're going to be using and that we are using. I got some really cool stuff that's coming up, and it's going to be a good year for everybody. I've kind of taken myself to a different type of content with the AI thing, but that's just because I've been learning through it and learning how to create things that's going to help us in the long run. And currently right now, we're developing a system that we think law enforcement could use in the future to help solve cases and solve crimes, and that we can use as an investigative tool to be able to solve crimes, find missing persons, dissect investigative information, and help us investigate crimes with new technology that we have never experienced before, that I have witnessed become something very powerful, and if utilized the right way, could really take us into a new level of investigative strategy and methods. So that's kind of where I'm at right now. It's really cool. It's actually really neat stuff, everybody. I mean, it's almost unbelievable, some of the things that we're capable of doing. You right now, as a person, just like me, we are capable of so much when it comes to like being able to have anything at your fingertips. You can create a song in about 6 seconds, an entirely fully produced song in 6 to 10 seconds. You can write an entire book, a script, generate audio, video, all with just your words and your imagination. And if that sounds unrealistic, believe it, because you're going to witness it happen right here on my channel. You're going to see it happen live, and you're going to be blown away at some of the stuff that you guys actually see, because it's going to be insane. It's really cool stuff. It's something that when you actually start looking through and seeing how we're creating these things, you guys are going to be just in shock on what the capabilities are, on how we could actually take over and basically help solve cases that have been unsolved for years. I mean, years, everybody. So that's all I got to say. On that note, everybody, I'm Anthony Greeno, and I will just click on this video. There's no audio to this video, but you can expect what you're going to get. If there is audio, it's not supposed to be there yet. It's not fully done, but I wanted to show you guys kind of what we're working with for tomorrow. So on that note, everybody, I'm Anthony Greeno here at True Crime Investigates, True Crime Rewind. Until next time, you guys keep it Southern style, y'all.
Liberty 35, come 6, 105 North Avenue.